such interesting
So
findings.
having spent the day focused on the presidency and bureaucracy, we'll finish the day by focusing more directly on the other parts of government with two interesting papers and a former chairwoman of the FTC. I want to say this panel, this whole conference was originally scheduled for December. We had to reschedule it due to a conflicting event. And by rescheduling it, we actually lost one of our authors who was not able to travel for this date, Jennifer No of the University of Chicago. She wrote a fascinating paper. It's not up on the website yet. She's still working on it. The paper's titled Agency Constitutions. And she describes agency constitutions as the authoritative set of documents for resolving intra-agency disputes over an agency's own separation of powers within the agency. And then she goes on to do a comparative analysis looking across agencies at the great variety of, as she describes them, agency constitutions. These documents that empower parts of an agency and constrain parts of the agency, which is why we're so glad to have Chairwoman Olhausen here to give her perspectives on her time as chair of the FTC. We're also very fortunate to have as a moderator for this panel Judge Stephen Williams of the U.S. Court of Appeals for the D.C. Circuit. You'll notice in his bio, he's written two books on the Russian Revolution, one called Liberal Reform in an Illiberal Regime, and the most recent called The Reformer, How One Liberal Fought to Preempt the Russian Revolution. I suppose the Russian Revolution is another form of non-presidential administration. So we're so lucky to be joined by the judge today. Thanks, Judge.
All right, I'm happy to be here. And the structure of this panel is a little bit different from the previous one in that there's no assigned commentator, but as moderator, I'm going to do a little commenting. So that's it. So we'll take the three speakers in the order that they're lined up here, and for further identification, you can see who they are in your program. And I understand that someone is keeping time.
Yes, sir.
Great. In the D.C. Circuit, as as many of you know, we set time limits, which we routinely ignore. That will not be the case here. Here we will adhere to them, and a fierce wave from our guide will make sure that that's true.
Okay. So my remarks today focus on one question. Can courts act like agency administrators? In other words, is judicial review a form of administration? So this inquiry motivates my exploration of what I call judicial administration. In the current debate regarding the constitutionality of the administrative state, the conversation is focused on limits to what agencies can do. However, there is less concern with potential limits to what courts can do vis-a-vis agencies. And so my work engages this inquiry as well. So for context, consider presidential administration, which we have been discussing all day, right? The idea that the president wields control over agency action. Now we know as a general matter that presidents can legitimately oversee agencies through the appointment of agency heads, internal review of the regulatory process, and other forms of agency oversight. Now, the controversy underlying presidential administration kicks in when the president steps into the shoes, as Adrian Vermeule has put it, of an agency head to administer a statute himself. That is, when the president himself makes a policymaking decision, despite the fact that the power to implement the law is delegated by Congress to the agency. I argue, too, that courts as well engage in the administration of law. Courts, too, can behave as overseers by making sure that agency actions adhere to the Constitution, the Administrative Procedure Act, and other legislation. And when a court directs a policy outcome, the court is behaving as a decider in lieu of the agency to which policymaking authority has been delegated by statute. Now, this terminology, overseer and decider, comes from work by Peter Strauss and has been repeated in other literature on the topic. Okay, so now that I've introduced my topic, my talk will continue as follows. First, I'll highlight long-standing tensions between the overseer and decider models of judicial administration. Second, I'll argue that there has been a recent overlooked turn toward the decider model. And third, I'll note some implications of judicial administration, particularly the decider model, for the ongoing debate concerning the constitutionality of the administrative state. I think the talk will take around 12, maybe 13 minutes. Okay? I talk quickly, so maybe less. Okay. So I define judicial administration broadly as judicial review that influences agencies' implementation of statute. Now, one example of judicial administration involves the judiciary reviewing agency adjudication to ensure that it complies with due process. So many of these decisions hail from the 60s and 70s, a period that Thomas Merrill refers to as a period of judicial activism. One example is Goldberg versus Kelly, generally considered to be the apex of the court's requirements for administrative due process. Now, in this case, the court held that the government must provide thick procedural protections before terminating public welfare benefits. And by employing a cost-benefit test that was aligned towards the individual's interests in welfare, the court arguably assumed the role of administrator in this case. In another case from this time frame, the Department of Agriculture versus Murray, the court mandated that due process required a policy in which adults that were claimed as dependents by individuals not eligible for food stamps might nonetheless themselves qualify for food stamps under the Food Stamp Act. Now, in regards to this case, Jerry Mashaw argues that instead of allowing the agency to follow a feasible model of bureaucracy administration, the court dictated a moral judgment model of justice that led to a different policy outcome. The Supreme Court has also gone so far as to allow structural injunctions. So in a structural injunction, a court orders a federal agency to implement a forward-looking administrative remedy in response to a constitutional violation by that agency. And so, for instance, in Hills versus Gautreaux, also from the 1970s, the Supreme Court found that a lower court could issue an order requiring the Department of Housing and Urban Development to implement a structural remedy in response to a decision in a class action suit finding racial discrimination in housing and urban planning. More than one commentator has argued that this remedy was, quote, an illegitimate judicial foray into legislative or executive terrain, because the court not only decided that the agency violated equal protection law, but also created an administrative policy to fix the violation. Now, as noted thus far, the judicial enforcement of individual rights requirements has consistently been critiqued as legislative policymaking, in which courts are acting as the deciders of policy. Now, in response, I argue that although the judicial intervention in these examples is significant, it nonetheless comports with the overseer model. This is because administrative process affects the rights and privileges of individuals, matters that go to the heart of values the judiciary is empowered to protect, as Gillian Metzger has noted in her work on administrative constitutionalism. I argue as well that judicial intervention in rulemaking is also consistent with the overseer framework. So in the mid-20th century, courts often required agencies to add procedural mechanisms to rulemaking, such as oral argument or ex parte communication bars. And this practice was rebuked by none other than the Supreme Court itself in the Vermont Yankee case. In this case, the court determined that it exceeds the limits of judicial power to force agencies to implement rulemaking procedures beyond those required by Congress or agencies themselves. But that having been said, Vermont Yankee overlooks the due process implications of procedural safeguards, even in rulemaking. And for instance, as Cass Sunstein argues, the decision of the lower court in Vermont Yankee itself amounted to an insistence on procedural safeguards and therefore ought not to be understood as a usurpation of legislative or executive prerogatives. As part of so I get more and more controversial as I walk along, okay? As part of the overseer model, the judiciary may also engage in hard look review. That is, ensure that agency actions comply with higher standards of expertise. So Cass Sunstein characterizes hard look doctrine as the most prominent recent manifestation of judicial control over the administrative bureaucracy. Now, in hard look, the judiciary applies the Administrative Procedure Act's arbitrary and capricious standard, which is usually a very low bar. But under hard look, the court takes the agency's development of expertise to task. And both functionalists and formalists alike, including Thomas O'Garrity, Merrick Garland, and Ronald Cass, so strange bedfellows in many ways, have argued that the court has behaved as the decider of policymaking outcomes via hard look in cases like State Farm and Massachusetts versus EPA. But nonetheless, I contend that hard look review falls under the overseer model for the most part. So first, rather than seeking substantive outcomes, courts apply hard look to evaluate the appropriate level of agency responsiveness to the president's agenda. Second, hard look review is concerned with expertise, which, as Frank Goodnow and Wallace Sayre and others have suggested, is not a matter of political decision-making that belongs to either political branch. And finally, even if a court finds an agency's policy to be arbitrary and capricious, it generally remands the matter to the agency to make the final policy, keeping the court's decision in mind. So despite the judiciary's traditional emphasis on overseeing agencies, I do note that there has been a recent turn towards an overlooked mechanism of the decider model, administrative statutory interpretation. So more specifically, judicial statutory interpretation can lead to judicial policymaking when it usurps the policymaking or gap-filling power delegated to agencies. One example of this is Sturgeon versus Frost II, which was decided just last year. So in this case, the Supreme Court interpreted the statutory language public lands in the Alaska National Interest Lands Conservation Act to exclude navigable waters, and so concluded that the National Park Service's regulations do not apply to these waters. This decision was unanimous, but the divergent justifications of the majority and the concurrence are telling. Now, the majority decision, written by Justice Kagan, declines to defer to the agency's interpretation of public lands because, she says, this language unambiguously excludes navigable waters. However, the concurrence, written by Justice Sotomayor and joined by Justice Ginsburg, acknowledges that the language was ambiguous, and the disagreement between the Ninth Circuit and the Supreme Court as to the meaning of the term public land suggests the same, that the term is ambiguous. But the concurrence signs onto the majority's decision because the majority's reading of statute is cogent and because of the important regulatory pathways that the court's decision leaves open for future exploration. So in other words, the concurrence acknowledges explicitly that the Supreme Court is making a policy decision as opposed to giving voice to unambiguous statutory meaning. As functionalists, this doesn't trouble them much, but it should trouble formalists. Okay, so the question then becomes, is judicial administration a legitimate use of judicial power? Is it acceptable for courts to influence administration in various ways? Or could these approaches to judicial review transform oversight into overreach? Now, one way to answer this question is under a separation of powers paradigm. The overseer model of judicial administration is perhaps the most legitimate under the separation of powers, especially when it concerns administrative due process and public accessibility, that are both judicial and constitutional and thus within the core purview of the judiciary. I also contend that oversight of administrative expertise is defensible within a formal separation of powers framework because the development of expertise does not belong to either political branch. However, constitutional limitations to judicial administration may kick in when the court exercises legislative or executive power as in the decider model. So one example is when courts issue structural remedies in response to constitutional violations by agencies. Another way that courts may violate the formal separation of powers is when the judiciary engages in the gap-filling or policy-making power delegated to agencies by the legislative branch, or that is associated with agencies given their role in the executive branch. Okay. So why does all of this matter, besides the fact that I find the dynamics interesting personally? Judicial administration has implications for the debate regarding the legitimacy of the administrative state. Prominent formalists, including Justice Kavanaugh and others, have argued that Chevron should be overturned, that courts should no longer defer to agency interpretations, but rather than solving a constitutional problem, overturning Chevron and allowing the judiciary to behave as the policy-making decider could lead to judicial aggrandizement at the expense of the legislative branch, at least under a formal model of separation of powers. Perhaps instead of uncritical advocacy for the decider model of judicial administration, formalists might focus their efforts on reinforcing legislative control over agencies. In addition, those who view judicial intervention as an antidote to agency power should focus on bolstering the overseer model of judicial administration. This could include judicial engagement in the enhancement of procedures, the oversight of agency expertise, and in ensuring that agencies follow Congress's broad directions without replacing agency policymaking with judicial policymaking. Thanks for listening. I look forward to your discussion. And I stayed in my time limit, which is very, very rare. Thank you.
Great, thank you. Thanks, Adam, as well for, where are you? Oh. Thank you for organizing this very interesting day and conference. I've learned a lot, and I'm looking forward to learning a lot from everyone as I'm presenting somewhat newish work here. The title of my paper is Agency Failure and Individual Accountability. But what this paper is really about is about a particular tool of congressional control of executive agencies. In particular, I'm looking at agency disestablishment as a tool by which Congress can get what it wants in terms of performance out of executive agencies. So to give an overview of my talk, I'll talk a little bit about what kind of tool agency disestablishment really is. I'll describe some of the expectations that we might have based on rational choice theory, political science literature about how disestablishment might be used. Then I'll get into what I consider to be the heart of the paper, basically looking at what the employment consequences for disestablishment actually are as it applies to agency staff. So what happens to the staff after an agency is disestablished? The primary takeaway from the empirical findings in this paper are really that disestablishment does not do all that much to influence career trajectories for most federal employees. So that's the big takeaway finding. Most of the time, the consequences are much more minimal than one might expect. I'll conclude the talk by briefly touching on a couple case studies that I've conducted that I think can help explain why Congress does not do more to punish the staff or apply accountability to the staff as a result of these disestablishment events. Okay, so disestablishment is a tool that I think roughly it means we typically have in mind two things that Congress could do. On the one hand, it could take away the statutory authority of an agency, or it could zero its budget. So those are two techniques that can be used to disestablish an agency. There are powerful techniques. How powerful a tool is this, and why? Well, I think a lot of political scientists and public administration folks and law folks have an intuition that this is a very powerful tool indeed. This is like the nuclear arms of congressional control of executive agencies. And the reason for this intuition is that unlike many of the forms of congressional control that are out there, this is one that actually influences all of the agency staff where they eat. You know, this is something that can result in loss of salary. You got to go out and look for a new job. So this is really powerful medicine. So when should we see disestablishment used? Normatively speaking, ideally, what would we want the use of this tool to look like? I don't really see a lot of articulations of this in the literature, so I'm going to do what bureaucratic politics scholars do and fall back on principal agent theory when I don't know what else to say. So basically, Congress has a problem in delegating policymaking authority to agencies. You know, it can give responsibility, but then it's going to have a hard time observing what the agency actually is doing, what it could have done, and so there's this big problem of moral hazard. And if the moral hazard problem is bad enough, then you might not get the formation of this relationship. So there won't be a delegation because I'm too scared of how the agency might take advantage of me ex post. So what do you do about this? Well, if you have ex ante and ex post control mechanisms, then this can help. So to give an example from the personal injury context, we know that if there's a contingency fee arrangement, I don't need to know as a client whether you're doing a particularly good job as a lawyer, because you have this, our interests are aligned, you get a higher fee to the extent that you get a bigger judgment. So the theory goes. Now, in the case of Congress delegating to agencies, it's a struggle to find ways to reward high performance in the same way. So what they might plausibly turn to is sanction. So if I can have an arrangement where if you mess up, then I kill you, then that's a mechanism that can generate a lot of effort, a lot of performance by an agent who I may not necessarily trust. So as long as I can observe when performance has been bad and punish it appropriately, then we should have a happy state of affairs. Now, the problem is that sometimes agents mess up and fail, even though they're working hard and they're talented people. And so you have a problem then of what do you do as a principal when you confront an instance of failure ex post. So I've seen an agent has failed. Now what do I do? So on the one hand, you can, if you really believe that the agent is a good agent, you can fire them nevertheless, which is probably good for motivating all the other agents that you have arrangements with. The bad side is that maybe this isn't the best thing to do in a particular instance. So there's this deterrence problem. there's a question of the trade-off between deterrence and the right thing to do in this particular case. So broadly, these kind of concerns lead me to expect significant employment consequences for agency staff, at least some of the time, probably a lot of the time following instances of failure. So those are what my expectations are. Now, let me explain the research design that I use in this paper. This paper relies on a really large recent data set release via FOIA of personnel records from the Office of Personnel Management. This covers basically every federal employee since 1973. And what's interesting, which is probably a lot of people in this room, I'm guessing. So what's interesting about this data set is you can actually track individual careers over time in this in a way that has not been possible to do in the past. So this is what I'm going to leverage for my paper. I'm going to look at the employment consequences of disestablishment by focusing on a particular agency, say like the Federal Home Loan Bank Board, which was disestablished in the late 80s following the savings and loan crisis. I'm going to look at this agency in a period prior to disestablishment. And for each of these agencies' employees, I'm going to go look elsewhere in the federal government for another person who looks exactly the same as that person in the Federal Home Loan Bank Board in terms of all the background features that I can find that are predicting their employment trajectory. So I'm going to look at how many years they've been in government, how old they are, what's their GS number, these kinds of factors. And so with this synthetic agency, I'm going to be able to track the career outcomes in that case and compare with the career outcomes for this group of employees who were working for an agency prior to disestablishment. And the main outcomes I'm going to focus on are, well, what proportion of each group are in government? What kinds of salaries are they earning as time marches on? And also, are they struggling to find a consistent employer within federal government? So you might imagine that if my agency is disestablished, maybe I don't leave the federal workforce entirely, but I'm going to bounce around several different places and never really find the home that I had before. Okay, so I do this, and I do this kind of analysis not just for the Federal Home Loan Bank Board, for about 40 instances of disestablishment where we could plausibly see these disestablishments as resulting from significant failures at the agency. And what I find is that in about 85% of these cases, there's no discernible employment consequences in terms of the number of people that are in government, the salaries that they're earning, how stable their employment is. There are a few instances where you see significant layoffs. You never see the entire workforce getting laid off and disappearing from the federal payroll. You might see about half of them getting thrown off. In a few cases, you actually see not only no significant turnover resulting from disestablishment, you actually see salaries, or lifetime earnings, I should say, going up as a result of disestablishment. So the employees of the disestablishment agency are going to earn more than their comparators did working for other agencies. So, one question we might have is, well, how is this possible? How could there be such little impact to disestablishment? The case of the Federal Home Loan Bank Board is actually quite instructive, because what Congress did in disestablishing the agency is to create a new agency called the Office of Thrift Supervision that it immediately transferred the staff, the equipment, the plant, everything, and the mission to this new agency. And so this is what actually seems to happen the vast majority of the time disestablishment is used. So the paper then looks a little bit at, well, what's different about the cases where disestablishment really does do something to these agency staff? And so I'll talk a little bit about two cases where you have divergent things happening. So the Renegotiation Board was an agency that its purpose was to go into military procurement contracts that had been entered into by the Defense Department and evaluate whether the contract was unfair to the taxpayers, whether there was excessive profits in these contracts. So this agency was not particularly successful in this task for a long period. It initially had a lot of success getting recuperating profits for the taxpayer, but it didn't ultimately. Eventually, it kind of fell into a state where it was only targeting smaller procurement contracts, not really focusing on the big stuff. So this agency was disestablished. About half of its staff were laid off. And so I do a little case study, a little legislative history to understand why were the staff hung out to dry in this particular instance. So one key factor that seems to emerge in the congressional debates is there's a pervasive sense that the agency is obsolete, that the Renegotiation Board no longer serves a useful purpose, its mission doesn't need to exist anymore. Now, this, I think, is quite questionable. There is more spending on military procurement in the period where the agency is disestablished than there were before. What I see as more of a proximate cause of the disestablishment is actually the interest group politics that are occurring around the agency. So in the early 1970s, the Renegotiation Board looked as if it might become a more effective agency. There was a new commissioner on the agency who was bringing a lot of energy to the task. There's renewed interest in Congress in having a strong renegotiation board, and this is what prompts a counter-response by the defense lobby to sow doubt about the necessity of this agency and its mission, whether it's actually benefiting the taxpayer in any way. So I see the interest group politics as being a really important part of the story about why this agency staff faced consequences, not necessarily as a result of its low performance per se, but as a result of, paradoxically, the threat of high performance. So, which was inconvenient for the interest group environment in which this agency managed to find itself. So I think with the Commodity Exchange Authority, the precursor of the Commodity Futures Trading Commission, I see a very similar but reverse set of factors. This is an agency where after disestablishment, the staff managed to have higher earnings than they were expected to previously when you compared them with staff of other agencies. And again, I think it comes down to a lot of it, the strong perceptions that there was a need to upgrade this agency, that the mission of this agency was extremely important. Again, this feeling of necessity in Congress is rooted strongly in the interest group environment and interest group politics of the time. There's very few opponents of the agency. There are a lot of people, all the stakeholders for various reasons, see a stronger Commodity Exchange Authority as being in their interests. So you get success for this agency following disestablishment. So.
All right, thanks. So I've really enjoyed hearing the presentations by the two previous panelists. I think they're obviously very careful scholars of government and the administrative state. And then my role here is to give you a little insight into kind of the hands-on experience, like how you actually take all these factors, including the setup of your agency, the internal powers that a chairman may have, the powers the agency has, and put it into a unique political environment and see what the outcome was. So as Judge Williams mentioned, and Adam mentioned, I'm Maureen Olhausen. I was the acting chairman of the FTC. I was the commissioner of the FTC, appointed in 2012, and then became the acting chairman and ran the agency for a year and a half as the acting chairman. I was in the unique position of never having a majority as the chair. We had two commissioners, one Republican and one Democrat. We had a quorum. Someone asked me last night whether we had a quorum. Yes, we had a quorum under our statutes. We were able to take action. But I think one of the challenges was how do you get things achieved in this kind of setting where you can't necessarily force action to happen and where you've got a lot of uncertainty. So I'm going to talk a little bit about that and a little bit about how you can have an agency structure and it can give you certain powers, certain authorities, but culture matters a lot too in agencies. So when I took over as the chairman, as I mentioned, it was myself, it was my Democratic colleague, and I couldn't hire permanent bureau directors. I brought in acting. The FTC is primarily a law enforcement agency. It has consumer protection, privacy, data security, advertising kind of oversight, and antitrust oversight, mergers, conduct, things like that. It has two major enforcement bureaus, the Bureau of Consumer Protection, the Bureau of Competition, and they're both supported by the Bureau of Economics. So fortunately, the head of the Bureau of Economics agreed to stay on for a while, but I had to bring in acting bureau directors to run those two enforcement bureaus. And I was fortunately able to bring on experienced antitrust lawyer, antitrust consumer protection lawyer. So that helped, but it was something no acting chairman had ever done before. So that was a little bit of a challenge to say, can I do it? No one said I can't. So I'm going to do it. But with no ability to make a promise to these people, leave your career, leave your law firm, you may or may not have anything at the end of this. So fortunately, they came on board. And one of the challenges, and I think one of the things in DC we would have presumed, is that this is a recipe for gridlock. You have one Republican, you have one Democrat, you have a change in administration, a lot of uncertainty, a lot of temporary people, temporary in their jobs. Could an agency continue to function and function effectively in this kind of an environment? And I think having a clear mission that the FTC had, and also having the culture the FTC had, helped to create what I thought was a very successful time. So just to give you an idea, so in fiscal 2017, we brought 25 merger challenges, and we had took 15 settlement remedies in 15 other cases. So as a point of comparison, this was essentially commensurate with the enforcement record in the antitrust area of the Obama administration, where there was a fully staffed commission where the Democratic chair had a majority. And in 2018, so I was also chair in half of 2018, we essentially came up, met the same pace. Consumer protection, privacy, data security, lots of high-level issues, hot-button issues. We brought and either brought in court or settled 131 consumer protection actions, including 18 privacy cases. So despite the idea that you might end up with this kind of perpetual gridlock, we actually had more than 500 unanimous votes during that time period. And I think when people ask me how did that occur, I think a lot of it was from having a clear mission of the agency and the ability to, as the chairman, I was able to control. I mean, mergers you have to decide in a certain time period, but everything else you have discretion over what kind of cases come up. So my view was, well, I'm going to get agreement with a Democratic colleague by identifying cases where I thought the competitive harm or the consumer harm was very evident. So I wasn't going to get a colleague dissenting by saying, boy, there's just too much consumer harm in that case. I'm not going to bring it. And fortunately, the FTC staff, who I knew very well, appreciated the mission, and we were able to make a lot of progress. It's been an interesting time to see, as I've moved on from the commission, how have things rolled on, and a lot of the cases that I opened, investigations that I opened, have been brought forward, and the commission has embraced a lot of the work we did during that time period. So hands-on kind of trying to manage agency structure, political oversight, and some of the unique circumstances. Now, the other thing that I want to pivot to is to discuss, we were talking about judicial oversight and issues of administrative due process. So one of the other interesting facets of the Federal Trade Commission is the agency has administrative litigating capability. So it can choose to bring cases in federal court or through its administrative tribunal. And there's been this question about if the commission votes out a complaint and then it is litigated before the ALJ, and then the decision of the ALJ is appealed back to the commission. Is there a due process problem? Is this essentially a kangaroo court, or what are the actual outcomes there? So there have been some real questions raised about that process. So I did a study that's published and looked at 145 administrative litigation cases through the FTC, where the FTC actually rendered a decision. So the commission actually rendered a decision. So it wasn't settlements and things like that. It wasn't matters that went to federal court. This is what went through administrative litigation. There was a trial and then an appeal, and the commission issued a decision. So that was from 1977 to 2016. There were 145 cases. And so I took a look at this and to say, is this a kind of a foregone conclusion? If the commission votes out a complaint, it's tried, and then it's appealed, does it always uphold the original complaint? So interestingly, over the period that I studied, and the reason I picked 1977 is because there were a lot of seismic changes in antitrust during that period, so I was trying to get sort of more modern antitrust. So it was sort of when that started to really take hold in the courts. I didn't want to go back to some of the older cases and older approaches of the FTC that I didn't think were representative. So over that time period that I studied, the commission actually dismissed about 1/3 of the complaints. So it was brought a complaint, full trial, went up to the commission, and the commission dismissed one third of those. So it undermines a little bit the idea that this was always a foregone conclusion, that it was always going to uphold itself. About 16% of those were on the merits, right? So because there's always a change in jurisdiction, change in facts, or something that might justify the commission dismissing the case. Now, most of the complaints regarding due process have come up involving the FTC's antitrust authority, much less on the consumer protection side, but much more strong criticism on the antitrust side. And interestingly, the commission dismissed 29% of the antitrust complaints on the merits. So kind of a surprising figure. Now, over time, the FTC has used its administrative litigation mechanism much less frequently. So it used to bring a lot of cases through administrative litigation. It brings many fewer these days. But what was interesting about the time period that I studied, is that, so we did reach this time period where the FTC, from 2007 to 2016, actually upheld 100% of the complaints that had been brought. So it was like upholding the complaint initially brought 100% of the time. But there were much fewer cases brought. So there was this like great reduction in the number of cases brought through administrative litigation, upheld it itself 100% of the time. But then here's the other interesting factor. It was upheld on appeal in the federal appeals courts 100% of the time during that time period. So that was also interesting. Now, I know there's this question of deference to the FTC. Was it just getting so much deference? But one of the other interesting factors is if the agency was getting that much deference, if you went back to an earlier time period, which was 1987 to 1996, the commission was actually reversed by the appellate courts 50% of the time. So I don't know if its cases were much worse or if deference had changed, but I think that's kind of striking. Now, one other factor that I examined was, well, is it the same people, the same commissioners, who vote out the complaint who essentially then hear the appeal down the road? So I looked at that, and what I found was that actually in 72% of the cases, it was not the same set of commissioners who voted out the complaint who then heard the appeal and made a decision on it. So 72% of the cases, there were no longer the same commissioners, or they no longer made up the majority. So you would have assumed that where the people who voted it out and then heard the appeal, that could create a problem. Now, here's the really interesting twist there. If it was the same commissioners, they were more likely to overturn liability, more likely to say there wasn't the support for the complaint. So it's a little bit confounding for the presumption that, well, you can't be both the person who brought the complaint and hear the appeal. You would have thought it would have been the reverse. So just some interesting facts and figures. I think it just shows the presumptions need to be tested by facts. And that the agency's administrative litigation perhaps has been the beneficiary of better case selection, tougher standards in antitrust to bring a successful enforcement action, because when the agency makes a decision on an administrative complaint, that's not the end of the story. They get appealed to the courts of appeal, and the defendants get to choose whatever circuit they want, so they choose the one where the case law is the most favorable to them, so it's a little bit unusual. So anyway, I just thought it was, given the questions, it was an important duty to go in and actually uncover some of the facts, some of which were not what people expected.
Where is it published?
It is published in the Journal of Competition Law and Economics. And it's called Administrative Litigation at the FTC, Effective Tool for Developing the Law, or Rubber Stamp.
What percentage of the cases were upheld by the internal court?
What percentage were upheld by the internal court? Let me take a look and I'll get back to you. It's probably in here somewhere.
You see how that's pertinent, because only the ones that they upheld the complaint would go to appeal.
That's not right, actually. So either side can appeal. Oh, I'm sorry, you mean appeal to the commission? Or appeal?
Appeal to the commission.
Either side can appeal to the commission.
The agency can appeal.
If it lost, it can appeal to the commission. And the party, if they were found liable, they can appeal to the commission.
Yeah,
Both sides can
I
appeal.
can understand, but you lose in your own court and you can appeal to somebody else. There's something wrong with that.
Well, read the paper and you can.
Thank you. On to the comment
Yes,
period?
on to-
All right, okay. I'll try to be quite brief, and I'll proceed, I think, in the order in which they appeared. First, I was struck in this paper that the categories overseer and decider are used. Decider seems like a euphemism for usurper. Certainly, we judges are used to being called usurpers, so don't worry about it. Feel free in a later version to use usurper. Anyway, there's a lot of different issues, and so it's quite an extensive paper. I wanted to focus on a couple of things. One is the paper uses the term hard look. I have to say that's a term I never understood and have never used. However, you more or less equate it with application of State Farm. And State Farm seemed to me a case where the Supreme Court very largely took together a whole slew of doctrines developed in the DC Circuit long before I got there to regularize the process of administrative thinking and put them all together in one case. And actually, before State Farm came out, I made an argument in favor of those demands on the, quasi-substantive ground that if you're serious about expecting the agency, about having the agency comply with its statutory mandate, you had to have those requirements. You had to ask, you had to require it to indicate what facts it was relying on and support those facts. review them, subject of course to deference, but review the facts. Then you had, as a distinct operation, to apply discretion, policy-making discretion to it, and all the little tools of State Farm are devised at smoking out those two different processes and making sure that we know what steps the agency was taking, at least as well as you can. And
I agree.
of course, there's an area of law where we don't do that at all. In equal protection law, so-called rational basis law, courts just ask, well, could Congress have had some reason for doing this? And the reason can be invented later. That's all fine. No problem. You don't look at what legislators said. They could have had all kinds of crazy purposes. Forget it. If there was a potential rational basis out there in the ether, it's fine. Maybe this is judicial usurpation, but I certainly, to allow agencies, which are just the creation of Congress, to go about their business in the same way, I think would be lawless, a complete invitation to lawlessness. Legislators at least have to go back and seek re-election. Then on Chevron, in your talk you didn't discuss Chevron much, but I saw in the paper two sort of different views, and that was that a world without Chevron could be looked at through two different lenses, and they could overlap, I guess. One, you suggested that it might be, you said directive, I'll say usurpation.
I stick with, because I don't necessarily, I don't mean it derogatorily. It's not managerial judges. It depends on what your view of the separation of powers.
All right. In any event.
I defer to your use of it.
And you suggested, correctly, clearly, that uncertainties in the statute build in policy issues. So every statutory interpretation combines policy and highly technical sort of reading of the language, and that offers your sort of second view of a post-Chevron world, and that is that it wouldn't be very much different from the current world, and I happen to agree with that as a matter of prediction. I don't think that Chevron is the great menace that it's sometimes seen as. Essentially, courts try to make sure that it is the language that is guiding them to their result, period, full stop, and they know at the same time that they have policy notions which they don't want to get in the way and try to keep out of the way. I want to give you a hypothetical, and this relates to how Chevron might evolve. Suppose there were any remaining substance to the non-delegation doctrine. You'd all break out into laughter. Fantastic proposition. But if that were so, wouldn't any issue of major consequence that was uncertain in the statute either have to be resolved by the court as if the statute had really decided it, or lead to a finding of unlawful delegation? Anyway, that's just something to ponder. All right, on to the question of what happens to the poor devils in an agency that gets zeroed out.
Judge, let me just thank you very quickly for the comments and say quickly in response to your last point. Or third option, Congress takes back some of the power to specify,
legislate.
Right,
oh,
right,
yeah,
right.
Sure.
That's the other. That's the other potential.
That's possible.
That's the
that's
other.
possible.
You know.
I mean, talk about dreaming. Yeah.
Yeah. Right.
Okay.
Well, you know, that's why I'm an academic.
On the question of the fate of the people in an agency that is zeroed out, and you see the zeroing out, well, Actually, in the course of the paper, you posit, and you did in your talk, though they were sort of separated, different motivations. Killing the agency because it's been bad, or political changes in political forces make it essentially unsustainable, or it's perceived that there's something fatal about the agency's mission. So, you know, a whole range of things can lead to the killing off of the agency. I guess I'm very skeptical about attaching much importance to the fate of the individual people. Suppose someone's right out of the Kennedy School, and he's bristling with brilliance and ability to analyze issues, and he gets a job in some agency, and he performs as well as he can, but possibly the people at the top lack whatever's necessary to do the job, or the job is essentially undoable because it requires going against unmovable political forces, or it's too incoherent to do. So in the end, the agency is zeroed out. That's not because this guy was an ineffective civil servant. It's because of all these other things which can hardly be blamed on him. So I'm not surprised that most of them go on to find happy careers in another agency. Why some of them should get a bounce up, that is I don't know. Can't see a clear explanation for that. Now, on to Chairman Olhausen's paper, which I thought was extremely interesting, particularly because it relates to something that I'm concerned about. Before I get to those, I want to express a couple of caveats. I wonder whether the FTC, in this latter period, where in every case they affirm the initial, or they reach a decision which is based on the belief that the original complaint was correct, was sound, and then they get affirmed by the Court of Appeals. And you nicely balance deference and the respondent's ability to pick the circuit, and you know, I don't know about how those actually shake out. But I guess I would offer the view that, at least in the antitrust area, this is special because antitrust law really is if not 100%, maybe 99% common law. It's all a bunch of judicial decisions that people look at and try to analyze as best they can. So the critical areas, well, I'll put aside fact, come back to fact. In terms of legal analysis, there's not deference, but everyone's starting from the same place. Whereas in the garden variety agency review on appeal, the agency is invoking our regulation, which says this and it really means that, or saying the statute says this and it really means that, and the court is deferring. So it's the shift of power that the system creates to the agency seems to be much greater in those areas. Now the FTC's good record, I mean fabulous record really, in the last period.
They've had some losses since, but as the time I wrote the paper. So.
That's very impressive. I guess this is complete speculation, but I wonder if its good record, and again I'm sticking only with the antitrust cases, is based on the fact that it's sort of like a district court before the Court of Appeals, except that it actually knows something about antitrust law. I mean, you know, they're doing it all the time. They're very experienced with antitrust law. So it is natural that they would do well, I would think. I don't have any theory on the consumer protection aspect, although I'm guessing that it doesn't much depend on subtle interpretations of intricate regulations. I may be wrong there. Anyway, that takes me right into the question of agency structure. We know that the Constitution was based in part on Montesquieu's writings about separation of powers. We know that Madison said that the combination of the legislative, executive, and judicial powers in a single person is the very definition of tyranny. We know that the framers were generally familiar with Lord Coke, and more specifically with Dr. Bonham's case, saying that no person should be a judge in his own cause. Yet, we have agencies created where they make the rules. Of course, they make them as the delegee of Congress, which has passed the statute. They prosecute the case, the role of the executive branch, and they make the final judgment. So we know that it would be intolerable if Congress passed a law saying, well, this really hasn't worked out very well. I think we think all the powers of the other branches should be consolidated in us, and we'll do the whole thing. That it wouldn't pass muster. They wouldn't even try it. But we do have this, what I think in Madison's view would have to be described as mini tyrannies, created absolutely across the board and exercising a huge fraction of all federal power that it gets exercised. And to come back to the FTC, which seems, at least you're very convincing that it doesn't seem to have worked as tyrannously as Madison might have expected. Again, you don't have the dangerous doctrines of Auer/Kaiser or Chevron giving it you don't have them, they apply, but they're largely irrelevant, so that those great legs up for the administrative agency, for the residual old-fashioned judicial power, doesn't operate in that zone. So I think I've said enough, and we ought to move on to questions. Yes?
What is the opinion of these district judges and national injunctions? Whereas, as I understand, the Court of Appeals can only control what's within their district. But we have district judges below the Court of Appeals stopping presidential initiatives nationwide.
There's a panel discussion on that on Wednesday next week at the or under the auspices of the Administrative Conference of the United States.
I still have to hear the opinions of our panel.
Well, since I'm on that panel, I don't want to, but certainly others who want to buy that, to respond to that, that's fine.
I will say it's not a topic I have, prepared to address today. So.
You haven't suffered under it recently?
I don't know if
I'm sure this will come up in the panel. Again, not an area of expertise for me either, but I'm sure this will come up in the panel next week. But there have been some interesting sort of dueling scholars who have written recently on the topic. There's a paper that just came out in the Harvard Law Review that sort of pushes back against a previous paper that suggested that the history of these national injunctions is shaky. And so I think they're just varying in historical accounts. I mean, as to the constitutionality of it, I have my opinions, but perhaps I shouldn't opine, given that I'm not an expertise in the area. So, okay, I'll leave it at that. When in doubt, point people to literature, right?
Come to the ACUS discussion.
Yeah, come to the ACUS discussion.
I'm not a lawyer.
Don't have to be a lawyer for this. Yes.
So this is a question probably any of you could address, but mainly probably, thank you. Mostly for Brian's paper. just thinking about my experience, some of my research thinking about agency reorganization that normally happens, some dramatic event happens, we have a reorganization. To what extent have you looked at the data to determine is true kind of dissolution of an agency or just a rebranding of an agency? Maybe a breakup of an agency, but really they haven't changed all that much in their operations. We name it something different, but nothing's really happened, which could help potentially explain your results, which don't show much effect. If that's not true, I would also it's an interesting analogy to the private sector labor markets, where I think a lot of economic research has shown that these layoffs, no matter if the person's performing well or performing poorly in the organization, that they do have pretty dramatic effects on people regardless, they could be caught up in a downsizing of some sort. So it is puzzling from that perspective if you think you can use that analogy from that research to the public sector. So I'd be curious about your thoughts on this.
So I mean, one interpretation of the findings is that most of the time it is just kind of a rebanding or symbolic reboot of the agency. That's what disestablishment mainly is used for. So I think that is perfectly fine. There's been quite a bit of debate, I think, in the political science literature about how much agency mortality there is. There's this literature stemming from Herbert Kaufman's famous work, Are Government Agencies Immortal? And there's been kind of a pushback for in the current literature that says, actually, there's a lot more turnover than you think. And so this paper, I think, does a lot to push back against that. In earlier versions of this paper, I've thought a little bit about using some classifications from the corporate literature about classifications for reorganizations. There's a lot of different typologies that are out there. I am not sure at this point that it's helpful for the paper, but it is interesting to think about. I mean, there's definitely a lot of the disestablishments come as a result of mass reorganization kind of events. Like education was like this, Homeland Security was like this. And so it's not surprising in those cases, really, that you get a lot of continuity as well.
Yes, back there.
Thank you very much. The name is Yaya Fanusi. I came here this morning to find out what's good government, good administration. So far, nobody.
I can't hear you.
So far, nobody have indicated to me what good administration is. But they have here a quotation in Federalist 68, which Hamilton taught. So I want to ask, there's something in economics which is called time consistency. Now, do you think that Hamilton, on this comment here, today, what do you think he would be saying in view of the time he was writing, stability, slow change, chaos, and volatilization, were not existing? So how can you get good government when you keep on talking about formalism, legal this and legal that? What is the end result of good government, good administration? What is the product? That's what I want to hear. I've not discovered it today.
Well, yeah. It's a big question. If any of us could answer that question definitively, we would be making much more, I think, than we do.
Not in government.
That's true. That's fair. Yeah, no, right. Fair enough. I don't know. We'll have to talk. From the functional, since you decry formalist tenets, from the functional perspective, consistency is represented by the sort of living on of civil service despite the change in administration, by a sort of adherence to expertise and impartial values. But to the extent you see good government as government that is responsive to the people, then change is a good thing. Even volatility is a good thing because it's responsive to changes in government that were the result of the people's decision making. So, you know.
Oh, yes.
You've got two people in the same place.
Two remarks on Brian's work. My name is Dave Rosker, Office of Advocacy and Small Business Administration. I was having a conversation the other day with actually a colleague who pointed out that in the private sector, when people are fired, that actually does often lead to increased earnings by virtue of the requirement to go out and essentially market oneself again. And the civil servant sometimes does create sort of the incentive to not sell yourself for higher earnings. So that was the first remark. And the second is disestablishment is a sort of a nuclear option. And I'm wondering about other mechanisms that Congress has expressed its displeasure with an agency. And it strikes me that when it comes to, say, for example, independent agencies, that a refusal to confirm a quorum may be another kind of analog, knowing that refusal to confirm an appointee doesn't necessarily mean for the rest of the executive branch it fails to function. But in the context of, say, for example, Merit Service Protection Board or FERC or FTC, that basically the Congress or the President deciding not to have a quorum may be another way of Congress exercising its displeasure.
Yeah, so I'll say two things. I didn't really get a chance to say much about why the salaries went up in the case of the Commodity Exchange Authority. I think there were widespread perceptions that the agency was not sufficiently competent to handle its important task of regulating commodity exchanges. And the solution of Congress to this was to increase the pay grades for the new agency, and also increase the salaries. Now, the people who were in the Commodity Exchange Authority were very well positioned to take advantage of this opportunity. So you got the same people getting the higher pay. And maybe this is what it took to incentivize future generations of high quality staff. But we should be concerned when we think about increasing pay about whether this is just going to be a windfall to existing staff who may not be, the performers we'd like. The second question, I agree there are many other important mechanisms that I'm interested to explore. What I'm doing in this paper is taking advantage of some new recent data about employment trajectories. So we're going to learn, probably, you'll read in, not just me, a lot of people producing studies about employment trajectories of federal workers, because now we can observe this in a way that we couldn't. So I think that's very much a frontier of research.
Yes.
This question is primarily for Professor Shaw. Have you looked at any difference between negative rights, such as you might see in the Bill of Rights, and the more modern movement toward what might be characterized as a positive right, meaning something that someone desires the government to deliver to them, and the effect of that on how courts review, like the standard of review, and whether that shifts power from the legislature to the court to make the court more of the manager?
So like the comparison between liberties and benefits, for instance. Because when I think positive right, I think of a right that's in statute. So anyway, have I looked at for instance, is the treatment of individuals who are subject to administrative adjudication different depending on whether the matter is one of protection of liberty versus seeking a
for example, you were to characterize equality of education as a fundamental right. So you call it a fundamental right, and then someone goes to court and says, my fundamental right to equality of education has been infringed. And then the court has to decide, has it or has it not, which is different from saying, has your right to speak been infringed, which is, did the government do something to you?
I mean, a core concept of administrative due process is that you have to identify a right or a liberty through the identification of positive, so through the identification of some sort of clear explanation of what that right is. And so a person can't create a right to better education out of whole cloth. There has to be some either in precedent or in policies that the person is subject to as a public employee, for instance. There has to be something the person can point at to say, this is my right, and so therefore I deserve some sort of adjudicative process before it's taken from me, or this is my, and so that right there, I think, is an initial kind of a obstacle to people invoking benefits of administrative due process, because they won't be engaged unless they can point to a very specific, explicit right that's promised to them, if that makes any sense. Am I understanding your question?
Yeah, you're understanding. So let me give you a concrete example. This is at a state level.
Okay.
So in Kansas, the right to quality of education has been deemed a quote-unquote fundamental right.
Okay.
And so the result of this in Kansas has been that the courts have basically taken over the role of determining whether education funding is adequate, pulling that out of the hands of the legislature and basically telling the legislature, you have or you have not succeeded in meeting this definition. And so I'm just wondering, from your studies, if you've looked at sort of across the board, if characterizing something as a fundamental right when what it is I want you to deliver something to me, if that shifts power into the judiciary from the legislature.
That's very interesting. And states as the laboratories of experimentation and democracy, right? So it would be interesting to see in Kansas or in other states, to the extent that the legislature or precedent has developed new rights that we're not seeing at the federal level, whether courts then become more involved in ensuring the access to those rights. And that is traditionally the court's role, right? To adjudicate the provision of benefits or the dissemination of benefits. And so it would make some sense. Your general theory makes sense that once something is characterized as a right, that the court would then have more involvement in sort of ensuring access to that right. And I'm certain that what's happening at the state level would provide fantastic data for exploring that further. So thank you.
Yes.
Professor Shaw, I know you don't sort of draw out any policy implications of your study of judges and judicial administration, but sitting here I can't help but think about it, and I wonder, based on what you've observed in judges participating in administration, how should we think about the process for appointing judges, their tenure, all the things that Judge Williams enjoys by nature of his appointment? Should we think differently about, if we accept that judges play an affirmative role in administration, which has policy implications, how should we think about the judges who are doing the administering?
It's a great question, as all the questions have been. So if we view judges as policymakers, then we can no longer cast them as impartial arbiters of language, right? Seated at a distance and seeking to apply meaning in sort of an impartial way. Now they are policymakers to some extent, and so their views on policy can't help but become part of their decision making. And so we have to take seriously who they're accountable to, who they view themselves as being accountable to, the views that they sort of align themselves with, and perhaps take, for that reason, consideration of who's appointing them, under what circumstances they're being appointed. We can't sort of live under this I think ideal notion that regardless of who appoints a judge or the sort of trajectory of a judge's career, that the judge will be presiding over impartial processes if we take seriously the idea that judges engage in policy making to some extent.
Present companies.
Yeah, of course, no, or not. Maybe judges should be making policy. That's why I say I don't necessarily say usurper. I haven't taken a normative stance on this. It's primarily descriptive, believe it or not. So anyway.
He's an administrative law professor.
There you go. Who better, right?
Well, thank you very much. And this is the conclusion of the conference. I hope you'll join us for the reception afterwards. As the program indicates, the next public policy conference that we'll host will be on March 27th. It'll be on proposals for different aspects of regulation of new technology companies, ranging from Airbnb and other platforms like that to things like social media. So if you're in the area, we hope you'll join us across the river in Arlington. But thanks again.